Hello everyone, my name is Murad Mohammad. I am a criminal defense attorney in the state of Minnesota, and I wanted to take this opportunity to have a brief discussion on the law of self-defense, especially in light of the shooting death of the young man in Florida, Trayvon Martin. A lot of people have speculated as to whether or not the shooter in the case would have a self-defense claim available to him. It's difficult to say because we don't know the full facts of the case, and in almost any self-defense claim, the facts make all the difference in the world. This isn't meant to be legal advice for anybody, and if you live in another state other than Minnesota, the laws of self-defense may be very different than what we have here. As I said, the facts make all the difference in a self-defense claim. There are some general principles, though. For a self-defense claim to be something that would be available, you basically would have to establish that you're not the initial aggressor. You can't be the person starting the fight and then claiming self-defense. You've also got a duty to retreat. That means you've got to show that you had an opportunity to escape the situation. And if you didn't, there must be a reason why you didn't do that. And then finally, there's got to be a reasonable expectation of harm for you to have a self-defense claim available to you. In addition to that, your response has to be an appropriate response. You can't bring a knife or a gun to a fist fight, generally speaking. Now, there may be exceptions to that rule. The unique thing about a self-defense claim is that it's what's called an affirmative defense. You're essentially admitting the facts of a case. You're admitting that you shot somebody, you're admitting that you punched somebody or hit somebody. But you're saying that I had a legal justification or a legal excuse in doing so. And that's a unique type of defense, because you're basically admitting a lot of the facts that most people would dispute. So you're basically saying, yeah, I shot the guy, or yeah, I punched the guy, but here's my legal excuse for doing so. Now, just because you have a self-defense claim available to you doesn't give you license to go out and shoot or punch or hurt people. It's a difficult claim to make at times, especially since it's so heavily dependent on the facts. One thing that you might want to be aware of, though, is that in your own home, you have a different standard of care in a self-defense claim. In a defensive dwelling or defensive home claim, you actually don't have a duty to retreat. You don't have to retreat in your own home. In addition to that, you don't even have to establish that you're in fear of any great bodily harm. That's not a necessary component for defending your home. All you need to show is that the person is a trespasser and that the person is committing a felony. So that's the unique difference between a regular self-defense claim outside of the home versus a defensive dwelling claim in your home. Now, in any case, your response always has to be reasonable. You can't shoot somebody that accidentally wanders into your garage. Your response has to be measured and reasonable in light of the threat posed to somebody. So there you go. That's the overall general concept of self-defense and defensive dwelling. Please be safe, and thank you.